Universitas saat ini telah bertransformasi menembus batas dinding ruang kelas karena pendidikan tinggi sudah memasuki era baru. Universitas juga memainkan peran penting sebagai agen perubahan publik secara luas melalui sosialisasi dan penelitian berkualitas melalui kabar kampus. Oleh karena itu, ini saatnya para dosen menampilkan kompetensi serta hasil riset melalui berbagai cara diseminasi. Bersama Klinik Hukum dan Instagram Live Hukum Online, para dosen mendapatkan ruang berbagi perspektif kepada komunitas hukum terbesar di Indonesia. Untuk kebutuhan aktivitas perkuliahan, Premium Stories hadir dengan insight tentang isu-isu hukum terkini. Tak berhenti sampai di situ, Sivitas Akademika Kampus Mitra University Solutions mendapatkan akses untuk mengikuti kelas penulisan jurnal. Para mentor berpengalaman akan memberikan bimbingan tahap demi tahap, mulai dari proses penulisan hingga publikasi. Kemudian, untuk menunjang semua kebutuhan riset, Hukum Online pun menghadirkan akses bagi Sivitas Akademika untuk menjelajahi pusat data kami. Temukan ratusan ribu peraturan, mulai dari tingkat pusat, daerah, hingga surat edaran. Melalui setiap fitur dan aktivitas bersama University Solutions, Universitas mampu memaksimalkan pencapaian Tridharma perguruan tinggi dan meraih akreditasi unggul. Sudah saatnya kampus Anda bergabung bersama University Solutions dari Hukum Online. Universitas saat ini telah bertransformasi menembus batas dinding ruang kelas karena pendidikan tinggi sudah memasuki era baru. Universitas juga memainkan peran penting sebagai agen perubahan publik secara luas melalui sosialisasi dan penelitian berkualitas melalui kabar kampus. Oleh karena itu, ini saatnya para dosen menampilkan kompetensi serta hasil riset melalui berbagai cara diseminasi. Bersama Klinik Hukum dan Instagram Live Hukum Online, para dosen mendapatkan ruang berbagi perspektif kepada komunitas hukum terbesar di Indonesia. Untuk kebutuhan aktivitas perkuliahan, Premium Stories hadir dengan insight tentang isu-isu hukum terkini. Tak berhenti sampai di situ, Sivitas Akademika Kampus Mitra University Solutions mendapatkan akses untuk mengikuti kelas penulisan jurnal. Para mentor berpengalaman akan memberikan bimbingan tahap demi tahap, mulai dari proses penulisan hingga publikasi. Kemudian, untuk menunjang semua kebutuhan riset, Hukum Online pun menghadirkan akses bagi Sivitas Akademika untuk menjelajahi pusat data kami. Temukan ratusan ribu peraturan, mulai dari tingkat pusat, daerah, hingga surat edaran. Melalui setiap fitur dan aktivitas bersama University Solutions, Universitas mampu memaksimalkan pencapaian Tridharma perguruan tinggi dan meraih akreditasi unggul. Sudah saatnya kampus Anda bergabung bersama University Solutions dari Hukum Online. Universitas saat ini telah bertransformasi menembus batas dinding ruang kelas karena pendidikan tinggi sudah memasuki era baru. Universitas juga memainkan peran penting sebagai agen perubahan publik secara luas melalui sosialisasi dan penelitian berkualitas melalui kabar kampus. Oleh karena itu, ini saatnya para dosen menampilkan kompetensi serta hasil riset melalui berbagai cara diseminasi. Bersama Klinik Hukum dan Instagram Live Hukum Online, para dosen mendapatkan ruang berbagi perspektif kepada komunitas hukum terbesar di Indonesia. Untuk kebutuhan aktivitas perkuliahan, Premium Stories hadir dengan insight tentang isu-isu hukum terkini. Tak berhenti sampai di situ, Sivitas Akademika Kampus Mitra University Solutions mendapatkan akses untuk mengikuti kelas penulisan jurnal. Para mentor berpengalaman akan memberikan bimbingan tahap demi tahap, mulai dari proses penulisan hingga publikasi. Kemudian, untuk menunjang semua kebutuhan riset, Hukum Online pun menghadirkan akses bagi Sivitas Akademika untuk menjelajahi pusat data kami. Temukan ratusan ribu peraturan, mulai dari tingkat pusat, daerah, hingga surat edaran. Melalui setiap fitur dan aktivitas bersama University Solutions, Universitas mampu memaksimalkan pencapaian Tridharma perguruan tinggi dan meraih akreditasi unggul. Sudah saatnya kampus Anda bergabung bersama University Solutions dari Hukum Online.
Ladies and gentlemen, may I kindly request your attention as we prepare to commence our session?
I extend a gracious welcome to each and every one of you and trust that you are comfortably seated. Thank you. Ladies and gentlemen, may I kindly request your attention as we prepare to commence our session.
I extend a gracious welcome to each and every one of you and trust that you are comfortably seated. Thank you. Good morning, ladies and gentlemen, presenters and esteemed guests. Welcome to the second day of the
International Conference on Regulating Technology in Asia, Prospect and Challenges 2024, an Economic Research Institute for ASEAN.
My name is Violen,
My name is Ecclesia.
and together we will be your master of ceremony today.
Before proceeding further, we wish to express our sincere gratitude to our sponsors for their valuable support in fostering the success of the ICRTA and area UPH special event, namely
Badan Arbitrase Nasional or BANI Arbitration Center as our gold sponsor,
area as our platinum sponsor,
Hukum Online as our media partner,
Dr. Stephanie Hartanto, SHMKN, and Insinyur Boy Robianto, STMT, as our personal donators. Fee, for today's event, we would like to do things a little bit differently.
What is it, Elsa?
I will greet one of our special guests from Chiang Mai University, Thailand.
Sawadika! That is the spirit. Thank you, everyone. And I see some familiar faces here that have also attended the first day of the conference, right, Elsa?
Yes, right. I see some familiar faces too.
So, as some of you may know and already attend the first day of the conference, I think we can all agree that we got so many insightful information, right?
Yes, we learned so many things regarding the use of AI from several amazing guests.
And I'm sure on this second day, we can gather a lot of insightful information, just as compelling as what we have discovered on the first day. So Elsa, tell us, what is exactly our topic today?
So, our topic for this second day of International Conference is technology-driven transformation, implications for intellectual property and investment landscapes. But before we start the main event for today, I would like to remind all participants to remain calm and silent throughout the discussion.
Okay, thank you. And just like the first day, the fruitful discussion will be led by a very amazing chair. She's a business and international law lecturer at UPH Law Faculty. In addition to her active teaching role, she served as the Deputy Director of the Faculty of Law. As part of capacity building, she actively participates in the Indonesian government delegation as a legal counsel for various trade disputes involving the Indonesian government as the WTO forum in Geneva.
Other than that, she also trained UPH students in various business law competitions and established a tradition of excellence by winning those competitions. Regarding her educational background, she completed her undergraduate and graduate law studies with a focus on international trade at Pelita Harapan University. Before joining UPH, she gained professional experiences working in several law firms specializing in corporate practice. Please join me in extending a warm welcome to Miss
Jerry Shelman!
A very good morning for our presenter, guests, our students, and also all participants in this international conference. So finally, we arrived on the on the last day, and the second day of this conference. So for today's plenary session, we'll talk mainly on investment as well as IPR issues. So I believe those issues will be so relevant in case you are preparing your thesis, preparing for your assignment. So I believe this session will be fruitful for all students here. So when we talk about the potential of AI, we already discussed so many general topics yesterday. And then we would like to deeper when we talk about how the disruption of AI will affect the investment as well as the IPR issues, because I believe many of you have so interest talking about those issues. So as pointed out by the WIPO, in 2017, the machine was at most an instrument or a tool very much like a brush or canvas. But with the latest types of AI, the computer program is no longer a tool. It actually makes many of the decisions involved in the creative process without human intervention. So for this second plenary, we will have two speakers with us. I will briefly read their bio. The first one is Joel Shen. So Joel Shen is a partner in a corporate team at Witters Qatar Wong. He leads the firm's Indonesia practice and also the Witters Tech Asia team. Joel advises corporate and venture capital clients in cross-border investment, acquisition, and also joint ventures. Joel is recommended by Chambers, Legal 500, and ICRTA 1000 for his work in M&A, startup, and also emerging companies in Singapore and Indonesia. As for the second speaker, we will have our alumni, Wiku Aninindo. So Wiku is an associate partner in the intellectual property and technology practice group who specialize in the area of IP, representing and advising foreign and local clients since 2008. He has been dealing with all types of IPR work, from enforcement, registration, and litigation, as well as advising in the field of digital media, technology, and copyright. Keeping up with the fast development of internet, Wiku has expanded his practice area to cover relevant regulatory and compliance in the area of communication, informatics, and data privacy. Online infringement and domain name disputes are also Wiku's key recent practice. So for today's session, we will have like talk show type of discussion. So we'll give some questions and we expect more questions from the audience. Thank you. Okay, so I think for the first part of the discussion, I would like to start with investment and later on we'll discuss about IPR and go back to the investment and IPR. That's how we will arrange this second plenary. So the first question, Joel. Do you want to add some information about your bio, about your experience on venture capitalist investment as a start?
No, I think you are quite effusive. Thank you very much, Jerry, and thank you, UPH, for having me today. It's a pleasure to be here. It's always a pleasure to visit your green and verdant campus in Karawaci. As Jerry says, I'm a technology and venture capital lawyer. I help clients invest in tech companies. I help tech companies fundraise. I help clients acquire and set up joint ventures in relation to technologies. When I'm not in legal when I'm not wearing my practitioner's hat, I'm also venture staff at a VC and an investor in my own right. So very happy to be here today, to meet everyone, and to exchange ideas about investment in technology. Thank you.
Thank you, Joel. Next will be Wiku. Can you give me opening remarks in the informal way?
Yeah, well, thanks everyone. Thanks for having me, UPH. I went to the class of 2004, so you're still in elementary school, perhaps, most of you here in the room, but it feels like home. It's always good to be back. And, I've been with HHP since perhaps 2009, yeah. Starting as an intern, fresh graduated from UPH. And I've been dealing with advisory work, litigation work, enforcement work, assisting a lot of multinational clients in doing business in Indonesia. So this is a very good opportunity for me actually to share some of the experience relating to the AI development. But this is a niche topic. The more you talk about it, the more you learn about it. So this is just like a sharing session. Perhaps I could learn a lot from the audience too, because perhaps you are more familiar in using AI than even I am. So yeah, it's good to be here. Thanks, everyone.
Okay, thank you, Wiku. Please help to share the presentation, but we'll start with investment first, Joel. So when we talk about the index report, because we always start with data, from the report issued by Stanford University, they said that the total investment made by the private companies basically decreased compared with last year, for example. But I mean, like when we talk about total investment in the last decade, of course it will increase, right? So my first question, from your perspective, what will be your opinion on this kind of, investment, and how this data tell us about the progress of the investment made by the VC, for example?
Into AI technology specifically. Okay. I think there are a couple of angles to this. Thanks very much for the question. Am I audible? No. It's cutting out. Thanks. Am I audible? Perfect. So I think there's a couple of angles to the question. You asked, your observations, or the Stanford report that you referred to, reflected that investment into AI dipped between 2021 and 2022, but that on a cumulative basis, aggregate investments in AI had been increasing over the last decade or so. I think two reasons for the dip. The first, of course, was that interest rates had remained close to 0% until June of 2022, which means that cash was there was a lot more liquidity in the market before. Interest rates started rising, and I think by about September 22, or towards the end of the year, they were at something like 16-year highs, which accounts for a lot of the sort of liquidity draining out from the tech ecosystem and from private investments in technology in particular. So we find ourselves in the middle of what seems like a long and drawn-out funding winter for technology. So that might be one reason explaining the dip in AI. And in fact, AI remains one of the few verticals in which investors are actively investing. The second reason, of course, is that 2021, I think, was sort of really the beginning of generative AI, right? It was that pointy tip of the AI graph. And I think a lot of that initial spike in AI in that year, spike in investments in AI in that year might have been caused by what we in the industry refer to as FOMO, because, as venture capitalists pay to take risks, you'd be surprised to learn how much of a crowd mentality we have. So, that was sort of the beginning of that nascent and exciting technology, and I think there was a lot of interest in the industry. People writing small checks at first and then progressively larger checks as AI gained prominence. But that seems to have tapered off amidst high interest rates and I suppose more sophisticated investment theses. Thank you.
Okay, let's take a step back when we talk about venture capitalist kind of investment. So when we see some news, of course, they will invest in different sectors, right? So from your perspective, from your personal experience, what will be the preference? Like conventional businesses or AI-driven startups, for example?
I mean, it's different strokes for different folks, I think, and it really depends on what you mean by AI, right? I think eventually we'll see I was talking to Jack Selby the other day. I'm not sure if you know who he is. He's sort of member of the PayPal mafia, who started, who worked with people like Elon Musk, etc. And we were thinking in our discussion that we'll see a bifurcation in AI in future, right? Between sort of the large Microsofts of the world and Googles of the world that will, monopolize proprietary AI technology, and the vast majority of other tech businesses that will be driven by AI, right? So the AI of the future, there was a time, I'm not sure whether you recall, that there were lawyers walking around calling ourselves technology lawyers or internet lawyers, right? Today, everybody's a technology lawyer. Today, everybody's an internet lawyer. And, I see that as well in AI. AI will become ubiquitous. All companies will become AI companies. It really depends on what you mean by investing in AI. In this part of the world, much of the investment so far has been going into consumer technologies. Why? Because in Indonesia in particular, Indonesia is expected to be the third largest contributor to the consumer class over the next decade, right? Behind only China and India. This means that many of the investors here are tapping on the growth of the consumer market and are investing in businesses that would provide to new entrants to the consumer class all of the services and goods that they had aspired to before, but that traditional industry had difficulty providing. Services like healthcare, financial services, education, new entrants to the middle class. They want to be entertained. They want to buy shit online, things online. They want to travel, save, be educated, and have access to basic services like healthcare and financial products. So, this is where all of the money has been going to. Will some of these businesses be supported by AI? Will some of these businesses be built around AI capabilities? For sure. But is a lot of the money in the region going into sort of proprietary AI businesses? Probably not as much as we think.
Okay, thank you for your answer. So this will lead me to my next question to Wiku. So when we talk about AI and IPR, I think it's something that you cannot really separate these two issues,
Correct.
right? So please help to show the PowerPoints. So my first question will relate to this slide. Can you tell us what is the latest global AI developments? Maybe because you already prepared these fancy slides, you can help us to understand what kind of information that we can gain from this slide.
So thanks, Jerry. I mean, the slide is pretty much non-exhaustive. As you can see, there's a lot of regulatory development scattered around the globe. And if you notice, there's a lot of going on in the Asian, Southeast Asia region as well. So if we actually break down the issues relating to AI to several things, like for example, data privacy, online safety issues, and of course IP, there's got to be more to be done about it, actually. And a lot of countries are issuing guidelines, consisting of the ethical use of AI to ensure online safety and data protection. Not much on the IP side though, because on the IP side, it is really up to debates. For example, if you actually question who owns the AI in terms of the input, the data being fed to the platforms, and the output of the data and the outcome, artwork, everything generated from the AI, actually there's got to be up to debates and jurisdictional perspectives about it. We haven't seen much because this is actually being influenced by court decisions as well. And if you are actually seeing what happened in China, for example, we do have one jurisprudence and ongoing court decisions saying that AI-generated work could be protected, while the approach in the EU and the US is pretty much different. So the jurisdictional perspective needs to come into play. And as a user, from the user perspectives, the most important thing when you are using AI platforms would be seeing the terms of use in terms of services. So the contractual basis and nuance of it should come into play. And the more we are talking about it, the more we seem to confuse about AI, because this is actually an ongoing learning. We are feeding much data to the platforms, and the more we feed more data to the platforms, the more they learn about something. So this is actually pretty much ongoing debate and discussion, but the trends that we are seeing, at least on the regulatory perspective, more countries are actually heading towards the direction of issuing guidelines on the use of AI. Like, for example, the Ministry of Communication Informatics actually issued circular letter in the end of 23. Not much actually on the technical sides, but actually to ensure that the use of AI should comply with the, like, for example, data privacy, and should actually to be in line with the IP provisions in Indonesia. The same goes to Malaysia, Singapore, and Thailand. So it's becoming a trend, and we expect that there are more guidelines to be issued in the coming years. We are still checking whether more thorough and specific guidelines and even amendments of the copyright law will actually possible in the next few years to accommodate this kind of new development.
Okay, so now next question for you, Joel. So when we refer back to Wiku's presentation about like many countries, they started to regulate about this kind of data protection and also the AI. Do you think that this situation will affect your or maybe your personal or like experience investing in startup companies, for example?
Will regulation affect investor interest or investment activity in AI technology, is your question. Invariably, it will, but that describes the entire arc of human endeavor, right? Regulators are always late to the game because it's not in the nature of a regulator to regulate something that isn't there. So the narrative usually goes, the technology is developed, right? In this case, AI. Someone identifies the business applications of the technology, someone invests in that technology, and it then becomes influential enough and substantial enough that the regulator steps in and regulates it. In some jurisdictions, there tends to be regulatory overreach in the first instance. Some regulators are more prone to knee-jerk reactions. I'm going to ban this, right, than others. Some regulators are more calibrated in their approach, right? How might we engage with industry stakeholders to protect consumers, to protect, to ensure competition, for example, right? If the regulator overreaches, the tendency for industry is to push back, and then ensues this, goyang-goyang until finally we settle into a place of unhappy equilibrium where everybody is equally upset at everybody else. But that tends to be, the typical description of how things unfold in the world of new technologies. I imagine it will also be the case in AI, and as regulators firstly try and get their heads around what this animal is called AI, and subsequently refine the regulatory approach and policy framework for AI, businesses, investors will respond accordingly, as we always have. We've seen this happen before in technologies such as the blockchain more recently, right? In technologies such as digital payments, e-commerce, cross-border e-commerce.
We just tried this morning.
That's right. The infamous TikTok ban, delivery of media content, OTT. It's a familiar story to those of us in investment.
Okay. So I think at this point, all of us here, I think all of us at this point, we use like Canva to design our flyer or even like our assignments or even like your presentations. And also when we talk about ChatGPT, I think all of us at some point we use ChatGPT, right? Not only, to find initial information, but some of you, I think you also use it to, to perfect your writing or even like give inputs on your generative AI. So when we talk about ChatGPT, specific for Wiku, can you tell us, when we talk about this ChatGPT or even like the AI in Canva, it's so easy to produce image. You just need to type, and they will convert it to the image. As long as you put like specific prompt, they can come up with like good result.
Yeah.
So in your opinion, can you give us the comments? What do you think from the IPR perspective?
First of all, I wish ChatGPT exists when I was in in law school. Pretty much comes handy when it comes to homework. But the IB side of it, it's pretty much very interesting, because the GPT era, actually, when you are actually using the platform to generate something, they are actually using somebody else's artwork, somebody else's contents, be it like user-generated, or most of the time, some platforms are actually using scraper, like data scrapping, like gathering all the data from the internet and feed it to the platforms. So it is possible that you are actually creating artwork, you are creating even music based on top of the original creations of somebody else in terms of input. And that goes to the output issues, as I touched earlier. When you are actually generating something, but perhaps you are not sure whether you own the artwork, you own the music, or you own the contents. So that goes to the ownership issues. Like in Indonesia, there's got to be like, if I need to be frank, the copyright law is not really clear about it. But it is actually in line with the approach being taken by other copyright laws in other countries as well, because this is a niche subject, and most of it is unregulated. But most of all, that comes down to one principle, that it requires a human intervention and a person as a creator from the copyright perspectives.
Okay, so when we talk about human intervention also, or maybe like creative process.
Yeah.
So what will be the, like the middle ground? Because I mean, like all of us, I think when we want to create something, this is not like something really new from us, because maybe we got some inspiration, we got some references. So how to find a middle ground between the, creative process and also the, like all the data that we got from the internet, for example?
Yeah. So first of all, the AI platforms, if you're seeing the terms of use of Midjourney and Stable Diffusion, they are not claiming themselves as the owner of the data and the inputs. So if you are using the platform, you are actually feeding more information to the platform. They are not actually claiming ownership to the contents that you're feeding to the platform, but you are actually giving license to them to actually develop and to use it as a derivative work. So on the output side, they are actually not claiming ownership to your contents as well. Some of the platforms are actually saying that you own the content. Some platforms are actually not explicitly saying about the ownership, but the bottom line is that if you create something with AI and it is infringing somebody's right and property, you need to be responsible for it. So you cannot say that actually the AI platform owns the content, because you need to be responsible for the contents that you are actually using. If you are using AI-generated works for commercial purposes, for sure, then the owner of the original works would be entitled to challenge the use of the contents for commercial use. That's one of the example. If you're talking about the middle ground, from the EU directives, the European Commission actually provides a 4-step test to consider whether or not an AI-generated content could be copyrighted. One of it is actually originality and creativity, as you mentioned. So there are several steps. If there is actually a human process, human-assisted process during the conception, execution, and redaction, meaning that if you're actually creating concept about something like drafting, and also executing something, and also revising the outputs of the AI-generated work, you can actually claim copyright. But that is actually should be taken into consideration other rights as well, like other third parties' right that is actually assisting. So the thing is that you can actually claim content as long as it is within the parameters of the guidelines and the laws in each jurisdiction. But you need to be also aware of the terms of use of the platform as well. Yeah, that is actually the example of EU. Like in the US, if you're going to one of the case in the Copyright Office guideline, in the US, you need to actually disclaim if you are actually using AI to create the content. So if you are actually generating, like for example, comics by feeding prompts, by using prompts of like based on the novel or written work, you can only claim the copyright ownership to the written work. But you need to disclaim the ownership for the visual contents in the comic books. That is actually a fair concept as well in the US. But again, as I mentioned earlier, there's a China side of it. There's a decision saying that you can actually claim everything. So this is a confusing subject, of course. Everyone in the final year, we need more thesis about it. So please reach out for discussion. We tech lawyers are actually in the need of doing more research and doing more comparative studies, because as we speak, perhaps there's got to be like a new case going on in the UK and the US and China and Japan and whatnot. So the comparative side of it, this is actually when if you need to compare development of law and tech, of course, technology always wins. Regulatory always comes behind, right? So we are pretty much more reactive. But at least we can predict in our jurisdiction that what we need to do actually by learning from other jurisdictions. And this is when the law school really have a very significant role to it.
So maybe after this, don't be surprised when you receive like 100 emails asking you to become their supervisor for their thesis, because you are giving them like some ideas for their thesis. Joel, you want to add something?
I don't often talk about regulation because all I am is a humble transactions lawyer. But since we're encouraging the crowd to be as interactive as possible. I thought we on stage should lead by example. And I came across we're talking about ownership of IP, right? AI-generated IP. I came across an interesting idea the other day by a gentleman called Simon Chesterman, who's the dean of my alma mater, NUS Law School. And Simon, in his book called We the Robots, presents this idea. Well, firstly, the problem statement is AI, what he loosely refers to as the bots, right? Robots are creating all sorts of mischief in the world today. Self-driving cars are getting into accidents. Generative AI is producing, unprompted in some instances, artistic and musical and literary works. AI, people think, certainly at the ASEAN summit last year in Labuan Bajo, is going to displace or certainly change the employment landscape. Many jobs are going to become irrelevant. New job opportunities will be created. Simon has, to my mind, quite an elegant idea of how to address many of these concerns, which I'd like to present to the panel and possibly the floor for discussion, which is that perhaps we should simply recognize that robots are people too. Consider it for a minute, right? So if the AI was recognized as a legal person, it would be able to have ownership of all of the intellectual property that it creates. It would be able to be sued for any accidents that the driving car gets into or any property that it destroys. It would be able to be insured, right? It would be able to be taxed, to redistribute, I suppose, income to the job to those persons whose jobs will be adversely affected by AI. And if this seems like a very outlandish idea to the people in this room, the law has a long history of conferring legal personality on persons who were not legal persons before, right? The classic example of this is the company. The company is a legal person. It's a creature of law. It doesn't. You can't see it or taste it or eat it, or nor is it physically manifested in any way. But yet it is recognized, by the law as a person capable of owning property and suing and being sued in its own name. And to look back on our, frankly, quite shameful history. It wasn't until very recently that women, for example, were conferred, legal personality. They didn't have, full rights before, or indeed persons of color in some countries. So what's stopping the law from recognizing today that your robot is also a person, right? And that it should pay taxes and that it should be sued in its own name or, capable of owning property in its own right? Wiku, I think this one's addressed at you thoughts?
I don't know. We're in a country of 200 million people already, Joel.
You don't need more robots.
And the population is already booming anyway. So yeah.
Singapore's replacement rate, I think fertility rate is down to 0.96, which means in one generation our population will halve. So I think we probably need more Singaporeans. If we can create robot Singaporeans, that might help address some of the issues.
Okay, thank you. So while we talk about generative AI, follow-up question to Wiku. So when we talk about, legal framework in Indonesia, can you share with us what is the position in Indonesia when we talk about someone create any artwork or anything, and they want to get this artwork to be protected, but they have some support from AI when they develop it?
Yeah, that's quite a popular question I've been receiving a lot in recent years, because the position in Indonesia is pretty much conservative. The creator needs to be a person. There's got to be like originality of it, and there's got to be like a creativity side in the creation. So the question would be whether the use of prompts, although the prompts could be redacted in numerous times, perhaps, whether that would be sufficient actually to trigger copyright ownership. And in Indonesia, if you recognize perhaps in Indonesia, you don't need copyright recordal actually to create ownership. It is actually once it is fixated, once it is manifested in real form, then it is protected. There is a copyright recordal, but it is a voluntarily, not mandatory to create title and ownership. So we've been seeing a lot of recordals. We've been seeing a lot of even patent applications relating to AI, but we don't have the guideline as the United States have. Like the concept of like disclaiming some parts of the creation that is actually assisted by AI, we don't have that guideline yet. We are actually in discussion with a lot of scholars, a lot of folks from DPR as well, the legislatives. If there is amendment of the copyright law, this needs to be regulated. But the thing for now is that it needs to be, you need to see it from several angles. Of course, the copyright law provisions is one of it, but the terms of use, terms of service of platform where you are actually generating the AI from, that should be taken into consideration as well. And the bottom line is that you can actually use the AI-generated contents for any use, as long as it is within the parameter of the terms of use and service of the platform. But in Indonesia, if it happened that the AI content you are generating is infringing somebody else, right? Then those copyright owners, authors, or any other right owners are actually entitled to challenge the use of your AI-generated contents. That's the fake of what happened in Indonesia right now. Perhaps not as interesting as in other jurisdictions, but we are seeing the direction of more regulations and guidelines to be issued, and I know that there's got to be like more discussion among the government officials to it.
Okay, maybe follow-up question. So when we talk about AI, you mentioned briefly about input and also output, right? So when we talk about input, I believe when we talk about, you know, like, I think you mentioned about machine learning and also deep learning. I mean, like, of course they will get it from the data set.
Yeah.
So how you can really assess this kind of input and also output when they want to create something?
Yeah, for the input, I mean, like, there's the main issue would be the copyright ownership of the data being considered as the input, the data sets itself. If it's actually copyrighted images, for example, that would be problematic. We have one case happening in the US and UK, Getty Image, you know Getty Image, right? Getty Image versus Stable Diffusion, where the Getty Image is actually watermarking the images, but they are actually being used as the data sets in the Stable Diffusion. The case is actually ongoing, and that explains and that highlights the importance of like ensuring non-copyrighted works are actually being input as the data sets. But that is pretty much nearly impossible to ensure that. Because if you are actually using the data sets as being fed by the users of the platform, of course, you as a platform can rely on the terms of use that the users need to ensure that the data sets being fed in the platforms should be not protected by copyright. That's one of the examples. But the practical side of it is pretty much very difficult, actually, to ensure that to happen. So we know that, and we predict that more cases will actually follow, more discussion and challenges will follow on the use of IP as the data sets in the inputs. So right now there's a couple actually going on, but I think more and more monitoring on what is actually happening in other jurisdictions is actually required. Again, in Niger, the position is actually, everything is actually pretty much conservative, but we can always learn from other jurisdictions, as like, for example, in personal data protection, we learn a lot from EU GDPR, right? So this is a comparative study that needs to be taken, and you know, we always need more help from you guys. So yeah.
Okay, so my next question will be to Joel. So when we talk about AI and also they have a lot of IPR issue, I mean like when we talk about the total investment, we have found out that there are three main sectors that being interest for VC, for example. So when we talk about medical and healthcare, we talk about data management, and also lastly, of course, about fintech. So in your view, why this medical and also healthcare will be like the main focus of total investment when we talk about this AI startup technology?
Because there's a market for it. Because there's a market for it. Investors invest in things that make money, right? And especially when investing in very nascent technologies like AI, where the law is unclear about things like ownership of IP and how AI will be regulated in future. When I invest in early technologies, I evaluate investment opportunities in three baskets of risks. The first is the tech risk, which is, does the technology work, right? And in this case, we see that the technology, certainly in some applications, does work. The second is the legal risk, which is to say, does the company I'm investing in own the technology? Will the company be able to continue using the technology as it does today? And the third is the commercial risk, which is to say, is there a market for the technology, right? And in the case of, you mentioned healthcare specifically, and fintech, right, financial services, the market is there. Right? You are taking zero commercial risk with AI, right? Humans will live and fall sick and be in need of medical care, and AI is there to fill that gap, right? So as long as the product fits the market or addresses a need, the risk does not exist, right? So my risk is immediately limited only to the first two baskets, which is, does the AI work, and does the company own and is the company able to continue operating the AI as it does today?
So can you tell us more about the tech risk that you mentioned about?
Yeah, the AI simply doesn't work, right?
But it is time to prove it, right?
Oh yes. So it depends on when you invest also, right? Because if you look at a company that is completely de-risked, right? Tech works, legally no issues, and there is a large addressable market, very lucrative company. As a VC, you will be priced out of the deal. Right? It'll simply be too expensive for you to invest in. So venture capitalists are paid to take risks on capital, very often other people's capital, but we invest in high risk and high opportunity, high reward opportunities. So we take calculated risks. A completely de-risked investment opportunity is probably not a VC opportunity. There's other, sort of investors that would invest into that, but not a VC. So a VC must take some risk. If I evaluate an investment opportunity as having three baskets of risk, as I said earlier, I wouldn't invest in anything where we take, all three risks. From a personal sort of analysis, I would expect the company to tick at least two out of the three boxes. I might take one risk, and if I were to take a risk on a company, I would take the legal risk, because that is where I think, as a lawyer, I would be able to evaluate that risk and price that risk more accurately than other investors. But you're right, tech risks, there is a way of proving that the technology works, but not in all circumstances, right? So moving away from AI for a bit, if we were to invest in a pharmaceutical opportunity, right? There is a long gestation period before you produce a result, right? Before you produce, something that you can give to patients. You know, it starts with proof of concept and proof of safety, and then it goes through various rounds of clinical trials before finally you get the FDA approval. Now, because of that long gestation period, there is a big risk on tech, right? That the tech doesn't work. And it's very binary in nature because at the end of that process, you either have the cure for cancer and you become a trillionaire many times over, or you have something that cures cancer in mice, and you make no money from it at all. So, that's one perhaps exaggerated example of a tech risk. But, tech risks exist in all technology companies, right, including AI companies.
Okay. So, I mean, like when we talk about tech risks, because I like to watch movies, you can find many Netflix movies about this kind of VC and also, how they invest.
Yes.
So I think for all students, if you have interest to talk about technology and also you want to mix it with a legal perspective, you can start from this plenary session and also watch your Netflix and narrow it down to like specific movies, right? So let's go back to Wiku when we talk about IP. And I think briefly you mentioned about the disputes part, right?
Yeah.
So can you tell us about it? I mean, like when we talk about AI, and I think just recently we found in some news they discuss about the disputes between ChatGPT and also the other company, right? If I'm not mistaken.
I'm not even following on that. Yeah, that's got to be like a new case. But that's the thing. Whenever, as we speak, more cases are actually popping out like everywhere. And it's very interesting to keep up with the developments and the nuance of the disputes of it. But always the thing is all about the ownership of input and output. So it's pretty much as from the regulator's perspective, if I must say, if I'm actually among the folks in the government, then I need to follow what's actually happening in those disputes in several jurisdictions, like perhaps UK and EU disputes and US disputes and China disputes have different nuance of it. And we need to actually grasp the relevance on what's actually going on and what can be implemented in Indonesia. From the lawyer's perspective, we haven't seen any AI disputes yet in Indonesia. But it's about actually, we are actually counting down the days when somebody is actually feel objected about the use of somebody else AI generated content, and there's going to be like disputes about it. More from the output perspectives, I guess, if judging from the disputes environment in Indonesia, not really in the input, because all the platforms generating AI are actually overseas platforms. I'm not sure whether they are actually having local establishment in Indonesia. So there's got to be like not much disputes on the input sides, but the output sides, we need to expect more disputes perhaps in the coming years. So yeah, that's about it. And frankly, we don't have much tech lawyers here in Indonesia. More and more tech lawyers are actually needed.
We have Joel here.
I was about to say that's commercial advice for everyone in the audience, because there's not many tech lawyers. That's career advice, right? Because there's not many tech lawyers. You know where the demand is now.
Okay, so I mean, like when we talk about, because you talk about the tech lawyer, maybe I'll just ask you both general questions, because when we talk about law and technology, I think for now the curriculum in general, we haven't accommodated this kind of development, because I mean, I don't think like 5 years ago we discussed about this acceptable use policy. We talk about like typical terms and conditions. So now it's not only like the general terms and conditions, Like this morning, I just found out when I tried Canva AI option, so they have this acceptable use policy. So in your view, as our alumni and also, you know, half lecturer of UPH, not full time, what do you think the law school should accommodate this kind of development about law technology? Because I don't think we have like many experts from for now.
Do you want to take this first as the alumni?
Okay, Joe. To be frank, other universities are actually still grasping about the development. And pretty much the curriculum itself is conventional, not really engaging in discussion and not really inviting experts. If there is an expert, again, the quantity is really not as many as tech lawyers in other jurisdictions, and we need more. So there's a lot of things to do to catch up. If we're speaking about UPH, we are always the forefront of like niche issue like this. Like back in the days, WTO thing was not sexy, perhaps not sexy for every other universities, but we were the first doing it, among the first, I guess, and we're so good at it. So I think we need to replicate the approach this time to tech-related subjects. Of course, if you are actually seeing the regulatory sides of it, there's not much to be discussed because the regulations itself in Indonesia is actually keeping up with the trends. But if you are actually having classes full of discussions, that's got to be like very interesting because on this subject, everyone is actually as knowledgeable as I am. We are always learning something new every day, and that's the positive thing about it. And I guess, yeah, that's a lot of things to do by UPH.
I think one of the challenges to preparing young lawyers for a career in technology is that you can't teach it fast enough, right? Technology develops so quickly that, you know, assuming that your LLB takes 4 years to complete, by the time you graduate, everything you've learned about technology
changes.
in your first year is already obsolete,
Yeah.
right? Think about it. As you said, you know, a few years ago, generative AI was not even a nascent concept in most people's minds, right? So I think the role of universities is to teach principles, concepts of law, which can be applied to new technologies as they develop, right? Concepts of, you know, natural justice, concepts of consumer protection, concepts of having to, you know, protect one's personal data and privacy, concepts of, you know, having to respect one's proprietary rights, etc. And to inculcate this sense of curiosity in people that they would continually want to learn, as Wiku says, right? Everybody, you know, most people in this room, I think, would be more tech savvy than me, notwithstanding that I hid, you know, with this technology practice. So that...
We are dinosaurs.
Yeah?
Not yet.
I see sort of frantic gesticulation from the audience that our time has run out. Jerry, you know, the floor, I'll yield the mic to you.
Okay. I think we can give chances for audience to ask questions before I ask more questions.
And I encourage you to ask questions because, you know, unlike your
please do.
many learned lecturers and professors who stand in front of the room and pontificate and dispense pearls of wisdom to all of you, Wiku and I are practitioners. So, you know, we operate where the rubber meets the road, as it were. We encourage you to ask us about life in practice and sort of the work that we encounter in practice.
Okay, I think we have one, and then one there, and then you can go to center.
And in front, there's a
In front
lady in the third row who's asked a question as well.
So we'll take 3 questions first. Andrean, you can go first.
Okay. Hello, sir. My name is Hello, second year student, and my question is, and what if we provide AI about the information? Hello?
Can you give
Okay.
other mic? Wait.
This. Okay. What if we provide the AI an information that contains, let's say, how to analyze a business fundamentals, and all the theory that have been made and all the narrative that been happening, can they eventually make their own analysis better? And let's just say we give an information about Warren Buffett on how he made Berkshire Hathaway, or how did he use compounding in investment, and we tell the AI to analyze it and make it better. Okay, so then if that happening in this Web3 and blockchain and decentralized narrative, are there any limitation? Are there will be any limitation in regulating this? And how can we, as a tech lawyer, keep up with this?
I'll let Wiku answer the part about regulation in a bit, yeah, because it's these are the deep and philosophical questions of life.
And one more. And
Please.
do you think
Sure.
this decentralized narrative is good or not? Because if we made everything in decentralized, we cannot control it, right? Because it's decentralized. Yeah. So what do you think about this? Thank you.
Thanks. I'll answer the first question, which is about how tech lawyers can keep up. And I think the answer to that is to continually innovate, right? Wiku can answer the bit about regulation earlier. Your question, Andrian, is will a robot be able to improve on Warren Buffett, this famous investor's investment strategies? Is that your question? And how, given the potential of AI, how would we regulate it? So I think the answer to your first question is probably yes. The CEO of NVIDIA has said that we are a lot closer to AGI, artificial general intelligence, which is to say AI that approximates human intelligence than we think, right? Perhaps in some fields earlier than others. So AI, for example, can pass the bar exam, right? But not yet some quite technical medical examination. So we're coming close. And I don't think we're far away from a time when, sort of robots outperform humans in certain very specific tasks, right? And here we're talking about robots, so, or machine algorithms. So the more specific the task, the more likely it is that the robot can outperform the human. So, in a game like Go, for example, or chess, we would never, ever be able to beat a machine today, right? And as human tasks become more complex and, sort of analysis becomes more complex, machines will catch up. And I think they will catch up before long. I'll let Wiku answer the part about regulation, but as tech lawyers, our role is to innovate. What I tell my team every day is no client comes to you and pays you money as a lawyer to tell them what the law says, right? Your clients can read, so they don't need you to tell them what the law says. No client even comes to you to ask you what they can or cannot do, okay? When the client comes to you as a tech lawyer, as a reg lawyer, they've already made up their minds that this is what they want to do.
Yeah.
So your role is to advise your client, whether they're in-house counsel or the internal business stakeholders, as to what the risks and potential ramifications are for their business when they take this course of action on which they've already decided, right? So we can't say, you can't do this, that's not what they paid to do. We can't say, we can only say, if you want to do this, this is how you would do it to minimize your risk. These are the risks that you can't mitigate. Is that acceptable to your organization, right? And they go in with eyes wide open. And to do that, you've got to stay ahead of the game. And as regulation changes, tech lawyers have to adapt to those changes. I hope I've answered your question, Andrian, but the interesting bit is for Wiku to talk about.
Yeah, I think you pretty much sum everything. You answered about most of the question. Thanks anyway, Andrian, for the question. I mean, like from the regulations perspectives, the perspective, you know, this involves various aspects. From the illustration that you mentioned, not only IP, but also the consumer protection side of it, the online safety side of it, the competition law side of it. So there's got to be like a lot of angles that you need to take into account. And adding some more on Joel's perspective, actually, on the role of lawyers, we always knew that our clients most of the time always made up their mind already when they see us. The thing is that the navigating risks is actually the art of it, how you need a lawyer. So this is actually a growing subject. And the more we learn about AI, the more we actually monitor the development. Sometimes we get confused on the directions that the things are actually heading. But that's actually the beauty of it, the development itself. And if we as a tech lawyer actually needs to keep up with everything, we actually need your help, because again, this is some areas that everybody is not as less knowledgeable as everyone else. So yeah, I hope that answers your question in a general view. But yeah, if there's any more questions from the floor, please do.
Okay, we'll limit to 2 more questions. So please.
Yeah, hello, my name is Rasita from area, and I just want to ask about the AI ethical guide. So ASEAN has launched ASEAN ethical guide to regulate the AI developers. And you have just mentioned about copyright law, which is it's more tends to AI users to regulate the intellectual property. So before Indonesia launched the AI ethical guide, which one is actually more necessary to launch first, for AI ethical guide or copyright law for AI users? Or it should be together to launch about the use of AI. Thank you.
Okay,
Right, so
I think we should answer this.
Yes.
yeah, the thing is that for Indonesia, everybody is actually waiting for somebody to do something. Always like that in terms of regulations. But we do have the MOCI, Ministry of Communication Informatics, circular letter issued in December 23. Not much going to the technical sides, more on the ethical sides of it, pretty much general. But at least there's got to be like certain aspects that we as lawyer are thinking that this is actually the direction that more regulations will be issued. We do have the personal data protection already issued 2 years ago. On the data security and online safety sites, we are actually issuing more and more regulations. That's actually the trend, but not yet in copyright. So if I need to take a bet, I guess copyright will be the last regulations to be issued and to be adjusted with the developments of AI. More and more regulations on the personal data protection side, online safety, consumer protection even will be issued first, and then copyright. Because if you are actually regulating or amending the copyright law, there's got to be like a lot of nuance and perspectives that come into play, not really on the technology side, but perhaps from the music industry, the movie industry, and so forth. So it takes more time actually to adjust.
Okay, thank you. Last one, last question. Any more questions? Oh, there.
Okay, good morning, Mr. Joel and Miss Jerry. My name is Aldi Prajaputra Pajar. I'm a law student from the first year. So my question here is more specifically targeted towards Mr. Wiku. So earlier in one of your slides, I read in the guidelines part that I will recite it here. USCO will consider whether the AI contributions are the result of mechanical reproduction, an author's original mental conception, which the author save visible form. In that regard, I wanted to ask, what if, for example, I use AI as a tool to help extend my ideas, but not necessarily to take it as my own? So what if I take a general theme from what the AI has called as mechanical reproduction, but I extend upon it with my own ideas, with my own inspiration. I build my own arguments. So in that case, how will the barrier be created? How will it be separated? How much of that work will be attributed towards me or the AI? So in the end, my question is basically, how much of the work is my works or the AI works if it's a combination of both? Thank you.
Yeah, it's got to be derivative IP. But thanks for the question. The UNESCO, the corporate registration guidance is pretty much extensive when it is regulating the best practice in filing copyright recordals. As the first point that you mentioned, that relates to the author's assistant, actually, the mental conception to which the author gave visible form. So this is actually relates from, I'm not a US lawyer, but we are still seeing more and more case examples, actually, to consider this. But when we are seeing things what happened in the US, actually, that could be considered as derivative IP, derivative copyright. But when you are actually filing the copyright recordal of it, you need to disclaim what aspects are actually being assisted by AI, and what is actually your creative aspects of the work. So those are actually the perspectives in the U.S. As I understand, and you know if you're talking about the ownership again, that comes down to the terms of use and services in each platform. Most of the platforms are not claiming ownership of the output. You can actually try to claim the ownership of it, but you need to be responsible for the use. And once you actually registering the AI-generated works to the Copyright Office in the US, this is for example, some guidelines on the disclaimer and the things and aspects that you can claim in terms of ownership, that should be considered. And there's got to be like more examination to it as well. When the Copyright Office officials are receiving applications, they will actually see whether or not the disclaimer is correct, whether or not the information on the aspects that you're claiming into the ownership is actually in line with the law and things like that. So the perspective of the Copyright Office officials, and there's got to be like some kind of discretion to it as well in considering the ownership aspects of the output. So yeah.
Okay, to close our session, I think we learned so many new insights today from IPR perspective as well as investment perspective. So thank you so much, Joel and also Wiku, for coming here.
Thank you.
So our MC, you can come to the stage and we'll continue the event.
Okay. Thank you, Ms. Jerry, for leading the discussion, and also thank you for Mr. Joel and Mr. Wiku for the insight regarding the tax transformation and its implication for IP and investment landscape.
Chair and panelists, please remain on the stage because we would like to do an appreciation and documentation session.
Sorry, Kak.
Thank you.
Just the picture together. We have been friends, like for a couple of years.
Thank you to our fantastic speakers, Mr. Joel Shen, Mr. Wiku Anindito, and our beloved chair, Ms. Jerry. After this, we would also like to take a picture together with all the speakers and participants.
Okay, we are going to have a documentation session with all the participants and speakers and guests from the first day. So please, Davis and Stephen, you can come up here and then lead the documentation session. Okay, to all the participants, please come closer to the center, and then you can stand up so that. Okay, to all the participants, you can come closer to the center, and then you can stand up. Please do quick right now. Okay, maybe Elizabeth and Renee can come to the center to lead the crowd. And to all the speakers and presenters, you can fill in the first row. Okay, you can move. Yeah, you can move to the center. From the right side, you can move closer if you want, and you can stand up. Especially for those who is in the back, please do stand up. Okay. Okay. So all the dancer, please join to the center. To the center. Say count 1, 2, 3.
Okay.